Hi everyone, my name is Mason Rashtian of the Mason Law Firm. I want to talk about something that surprises a lot of people, and that is about slip and fall accidents. Insurance companies deny slip and fall cases all the time, even though the person is clearly injured. And it always comes down to one word, which is notice. Indeed, that word is so threatening to some attorneys that they shy away from accepting slip and fall cases. But what is notice? There are two types of notices that one who is injured must be able to prove in order to succeed in a slip and fall case. The first one is actual notice. That means the property owner or the person in charge of the property, like a management company, knew of the dangerous condition. It could be water on the floor in a grocery store. It could be loose dirt somewhere else. It could be a sidewalk that is cracked and not fixed. As long as the person knew about it but didn't fix it, that would be actual notice. But most people cannot prove actual notice because no defendant to date has ever said, I knew there was a problem, I just didn't want to fix it. So then, under the law, we have to proceed what's called a constructive notice. That also would show that the person is responsible. How do you do that? That means the condition was there long enough that should have been discovered by the property owner or the management company if proper inspections had been performed. But that's also could be difficult to prove. But here are some tips that will help you show constructive notice. Let's say you're in a grocery store and you're walking down the aisle and you slip and fall. First, you have to know what you slipped and fall on. So look to see if it's a liquid, and if it's not liquid, if it's potentially wax, whatever it could be. That's the first thing. We have to be able to show a causal connection between your fall and your injuries. So you have to see what it was that caused you to fall. Now, you may not know if it's water, you may not know what the clear liquid could be, but as long as you can describe it as a clear liquid or liquid that may be brownish in color or some other color, maybe it has a foam in it because it was mixed up with soap, that's all we need. But that's not enough. Look around to see if there's any signs that another shopper could have passed through the same exact area before your incident. How do you do that? Look for any footprints to show that somebody else before you may have walked to the same area. If it's water in a grocery store, look to see if there's any track marks from shopping carts in that puddle of water. Again, these tend to show that it was there long enough that at least one other shopper went to the same area. They may not have slipped and fell, but it shows that it was there long enough that they could have discovered it, they meaning the supermarket, and clean it up. The typical defenses that insurance companies use in slip and fall cases are that you weren't watching when you were going. If you had been watching, you would have seen the spill and avoided it. A lot of times they'll ask about the type of shoes you wear because they want to blame that if you had high heels, that could have caused you to fall. Or if you have worn out shoes, the bottom of the shoes were slippery and that caused you to fall. These are why it's important to look to see what caused you to slip and fall. If the bottom of your shoes are wet after slip and fall, that proves that you stepped on something. If your clothes are wet after you slipped and fall, again, that would show that you had made contact with some kind of liquid on the ground. So that's why it's important to be able to say what caused you to slip and fall. Best practice would be if you do see a spill, take a photograph of it with your phone. That way it shows the type of spill, the location of the spill, and the size of the spill. And if it's a liquid, it may show what color it is. If the liquid was incorporated with some kind of a cleaning solution, it may show some suds in it. So that's why it's best practice is to just take a photo of the spill. In addition to that, there are 3 simple steps that you must take in order to help your case and maximize your ability to either win the case or get maximum compensation. Number one is you should always report the spill after a slip and fall, because that shows the documentation from the incident, and that is something the insurance companies always look for. Because otherwise, anybody can say, oh, I slipped and fell on your grocery store a year ago or a month ago. That doesn't work. You have to show that you documented the incident and you reported the incident to either the management or whoever's in charge of the location where you slipped and fell. Next thing you must do is go get checked out by a proper healthcare provider. Not only helps you with your injuries, it starts setting up your treatment and shows a proper time as far as when your treatment started after the incident. So that is very important. The other thing you need to do is never ever give a statement to risk management or an insurance company about the incident before consulting with an attorney. It is very crucial that you don't do that, because if you do, they will tape record you and they will have you search certain things that they will use against you in any kind of a litigation, which surely happens after a slip and fall. So always consult with an attorney after a slip and fall and before you talk to risk management or an insurance company. If you or someone you know has been injured in a slip and fall incident, please give us a call and we will answer any questions you may have. My name is Mason Rashtian. My firm is called the Mason Law Firm, and we meet our clients by accident.